Okay, everyone, we'll go ahead and get started. Welcome to our second Law and Religion panel. As Chris Lund mentioned earlier, Category 4 hurricane decided to disrupt some of our event today, and so we've got some people joining remotely, and that includes Mark Storslee, who, despite the very calm look on his face, I'm relatively certain has a Category 4 hurricane blowing outside his window right now, which it's entirely plausible he may disappear at some point with a power outage. So, we're grateful that our tech people have been able to make this work so successfully. Let me introduce our panelists, and then I'll get out of the way. We have joining us today Lawrence Sager, who is the Alice Jane Drysdale Sheffield Regents Chair, Professor of Law here at the University of Texas. Mark Storslee is an associate professor at Emory University School of Law, and he's also an affiliated faculty member and McDonald Distinguished Fellow in the Center for the Study of Law and Religion. And Stephanie Barclay is professor of law at Georgetown Law School and the faculty co-director of the Georgetown Center for the Constitution. We have not discussed in advance who's going to go first. So, Stephanie, since you're physically here, you want to lead off? Apparently, you have a video as well, right?
Sure. Thank you.
Sure.
Yeah, the privileges of being in the room are that I get to grab the mic. So
there you go. Thank
you so much, Steve, for having me, and to Sandra for being so accommodating and just seamlessly handling all of these logistics so well, and to University of Texas and all of your students who've been really impressive. It's been great to get to know your students better. And thank you to Doug. What a special chance to be here to celebrate him. I'm going to tell you a few Doug stories before I jump into the substance of my remarks. So Doug is a big part of my journey into caring about law and religion at all, and to going into academia. So when I was at Covington, I filed an amicus brief in the case that Doug was litigating, Holt versus Hobbs. And it was such a pleasure to work with Doug on that case. He was encouraging. We kicked around some ideas together early on in the process. He ended up citing my amicus brief and being really encouraging. And it was that brief that ultimately led Beckett to ask me to apply to come work for them. So I didn't know that I'd be doing law and religion if it weren't for you, Doug. And then it was while I was at Beckett that Doug and I had a conversation where he encouraged me to think about academia. That was really meaningful for me. Speaking of that Holt versus Hobbs case, I don't know if you all know this, but Doug he starred in one of John Oliver's puppy oral arguments. There's a big dog in that case. I will feature that later where it's relevant to some of my remarks. And then one of my other favorite Doug stories from one of my Beckett colleagues is that right before he got up to do oral argument in the Lukumi case, he turned to them and said, how many chickens do you think were sacrificed so that oral argument would go well today? And apparently the answer is enough of them, because it went really well. All right. Sorry, my computer locked me out. One thing that I'm going to be talking about today is the work that Doug has done, especially with respect to the strict scrutiny test that has come to be so important in the context of religious exercise. Doug has done really important historical work, justifying that test, normative work, doctrinal work, helping explain how it can operate in a sort of coherent way. I think that there's probably no law and religion scholar who has done more to shape the field generally, and strict scrutiny in particular. So I'm going to discuss some of his really landmark contributions in this space. And I'll also note that I think Doug's work is more important than ever when we have, as was alluded to on the last panel, Supreme Court justices like Justice Kavanaugh, who has expressed concern about balancing and about strict scrutiny. Justice Gorsuch, joined by Justice Barrett, has expressed concern about the competence of the judiciary to balance incommensurable things. And then we've recently had concurrences or opinions by Judges Thapar, Newsom, and Oldham, all very influential judges, saying maybe we should just Bruinize the First Amendment. And for those who aren't familiar with Bruin, that's the Second Amendment decision that says that the protection of a constitutional right depends on finding a really close historical analog. And one question I think Doug has really fairly raised about that is, well, what are we finding the analog of? The religious exercise or the government regulation? The outcomes would change radically depending on your answer to that question. There's a lot of problems with that approach and concerns that I have, and I think Doug has. And so it's a reason, I think, to pay renewed attention to some of the work he's done in this space. So in one of his articles, the religious exemption debate in Rutgers, he spent some time talking about both text and historical justifications for a doctrine like strict scrutiny. He talks about the ways in which the text of the Constitution applies to all form of religious practice, central or peripheral. It includes conduct. In his Notre Dame Law Review piece, Religious Exemptions and Religious Behavior and the Original Understanding of the Establishment Clause, he talks about the way in which toleration applied in all of the colonies at the founding. Once the state had decided that minority faiths should be permitted to freely worship, the logic of toleration suggested that they should also be exempted from other laws that made their lives unnecessarily difficult. The impulses that led to toleration was that religious dissenters should be free to live in a jurisdiction and that their lives should not be made miserable because of their faith. Writing with one of our other colleagues in the field who's a giant, Tom Berg, in the Supreme Court Review, they both provided other historical arguments in support of this doctrine. So they pointed out that Justice Alito and Fulton had talked about the original meaning of the Free Exercise Clause, harmonizing founding-era state constitutional provisions. These state provisions, many of them, most of them, had provisos that would limit religious exercise for public peace and safety. And strict scrutiny is one way of giving meaning to those sorts of limitations. This idea that Judge Campbell has argued as part of our general law, religious exercise as a natural right, came with it some limitations packaged in. And the state constitutional provisions are one indication of that. The fact that the federal Constitution doesn't have that same proviso isn't necessarily dispositive, is if you think that religious exercise was understood as a natural right that pre-existed the text of those constitutions, and those constitutions are acting as a placeholder for a right that already had content, already had some limitations, but people sort of generally know what the meaning is of that right. This is also a really important contribution that Doug has made. So he and Tom talked about ways in which significant damage to property probably also fit comfortably within that sort of standard. And scrutiny of generally applicable laws, especially scrutiny of government interests, needs to happen at the margin rather than in the abstract. One thing Doug also did that has been influential for some of my work is he looked at some of the earliest cases that we have in some of the state courts, one in New York called People versus Phillips from 1813, and another from Virginia called Cronin, a decade and a half or so later. And the way in which they're doing just that, they're looking at the interests of the claimants at the margin, not in the abstract. One of the big challenges that has been made to religious exemptions is the idea that giving someone an exemption from a generally applicable law leads to sort of preferentialism or favor treatment for religious people that others shouldn't be entitled to. And in his article in the Notre Dame Law Review, Doug wrote about how that same argument had been raised in New York. The lawyer in that case argued, quote, "Whenever anyone shall claim to do what may justly offend the others, he claims an unequal, and so an unconstitutional preference." So this argument against religious exemptions has been with us from the beginning, and it failed in that case, and thanks to work by Doug, it continues to fail in modern cases as well. And also thanks to scholarship by folks in the room like Chris Lund, who tells us reasons why religion might be special enough for some of the protection that it receives. There's a similar holding coming out of the Commonwealth case in Virginia. These are cases that are where they're looking hard at what the government is alleging. And in some of the work I've done building on Doug's work, they're also asking questions that are really reminiscent of modern strict scrutiny. So take the New York case. There, the priest received a confession about a necklace that was stolen. The government is trying to force the Catholic priest to confess so they have more evidence about the crime. They're arguing we have an interest in reducing crime. If they were doing this in a modern day, they'd say we've got a compelling interest. And the court says, fine, good, reducing crime seems important to us too. But the court in this case doesn't just look at this in the abstract and doesn't just take the government's word for it. They say, you haven't actually shown evidence that forcing these sorts of confessions would have the natural tendency to increase crime. They also point out that they're worried that this sort of approach would be good for this case only, a ticket good for this ride only, because if all the criminals knew that their confessions could be forced to be testified in court, then criminals would stop confessing. And then the court says something they probably wouldn't say today and say, and if all the criminals stop confessing, then crime will probably go up. But it's an example of ways in which today courts still look at, are you government actually advancing your interest, or are you undercutting it? Are you doing things that make it less likely you're going to accomplish your supposed goal? So why didn't the Supreme Court or originalist jurists like Justice Scalia pay attention to some of this historical work? In Remnants of Free Exercise, in the Supreme Court review, Doug writes, Smith is probably wrong as a matter of original intent. Certainly there's no plausible opinion that can be written without taking account of some of the historical evidence. He also cites evidence by Michael McConnell that he says this work was completed before the court's decision, but it was published immediately thereafter. It wasn't brought to their attention. No one knew that the court was considering overruling what had been the strict scrutiny standard under Sherbert. Why were they considering doing this? In his Rutgers journal, he talks about how the Reagan administration saw Sherbert and Yoder as a prime example of judicial activism. They didn't run on this issue because they had an evangelical base, but the Justice Department was filing a lot of briefs at the Supreme Court that turned out to be influential, that were hammering away at this strict scrutiny approach every chance that they got. I think that the Reagan administration was probably surprised by the backlash when Smith came out and how universally it was condemned. But one thing that I so admire about Doug is that was not the end of the story for him. So we've talked about what a remarkable Supreme Court advocate he is, and as well as scholar, but he also did so much to influence legislation in this country. And so someone who can wear all three of those hats in the courtroom, in the policy space, at the federal and state levels, and the academic space is really remarkable. But he helped give some input on the RFRA hearings. He became essentially the primary legal advisor for our LUPA, the statute that came after RFRA. He was telling me that he wrote between 300 and 400 pages of testimony for our LUPA so that we could have the law in the books that we have now. He essentially wrote a book that is not over there in addition to all his other incredible works in order for that statute to be passed. And then has done so much since that time to help us flesh out what those statutes mean, how they should be applied, and how we can limit some of what the Supreme Court said about neutrality and general applicability in its decision in Smith, including in an article he wrote with my colleague, Steve Collis, where they distinguished between neutrality and general applicability in a way that has been of critical importance to the Supreme Court as they have fleshed out those different tests. So what are some of the ways that Doug has fleshed out the strict scrutiny doctrine very influentially? First of all, he has really coined the phrase the most favored nation approach, which is this idea that if government is providing at least one secular exemption that's comparable, then that's evidence, or it's at least relevant to the idea that they have to provide similar treatment to a religious exemption. This is the quote from Doug and Steve's article about this. Quote, "The question is not whether one or a few secular exemption analogs are regulated. The question is whether there is a single secular analog that is not regulated. The constitutional right to free exercise of religion is a right to be treated like the most favored analogous secular conduct. It is not enough to treat a constitutional right like the least favored, most heavily regulated secular conduct." This is an idea that still continues to have really significant impact today. So there's an evidentiary function that these secular analogs are doing under the law. Sometimes, if there's enough of them, it might undermine the fact that the government has a compelling government interest at all in borderline cases where we're trying to decide anew whether an interest is compelling. But what they also often do is that they point to ways in which, quote, this is from this article again, "generally secular exemptions mean religious ones are also possible." So this is one area where some of these arguments were relevant in Holt versus Hobbs. And if you could play the video clip really quick, you'll get to see Doug starring as a dog.
Facts. But the question is not just, is it conceivably imaginable that some prisoner somewhere could hide something in a half-inch beard, but could he hide something there that he couldn't much more easily and more securely hide in the hair on top of his head, in his shoe, in the lining of his clothes?
You're arguing for all half-inch beards, right? I mean,
yes.
we got to assume all half-inch beards are okay if God tells you to grow them, right?
Well, I think that's right. And again, subject to somebody producing evidence that we're wrong about some half-inch beards. But I think yes.
And what Doug goes on to argue in that case is because there are 44 different states would have protected the type of the bulldog was Scalia, yes, which I think is fitting. My colleague at Beckett, Eric Rosbach, who some of you know and has a distinct voice, was played by a duck, which I also thought was fitting. But if 44 different state prison systems can offer this type of exemption, and if that prison itself can offer an exemption for medical reasons, that suggests that the government could find a way to protect religion and still protect prison security. It's doing it in other contexts. And some of the arguments in Doug's brief, Justice Alito capitalized on when he asked your poor student on the other side who had to litigate that case, look, if we're really worried about the prisoner hiding things, contraband in his beard, couldn't we just do something like have him rub his beard and all the small revolvers will fall out? Like, surely there's another way to handle this situation. And I was sitting in the court when Justice Alito asked that, and that was another example of the type of language Chris highlighted earlier. So compactly, Doug is able to make an argument that just turns everything around. Doug has made important arguments normatively for why this sort of approach, when followed, reduces needless suffering, as Tom talked about. It's one of the most important ideals of America that we have exported other places, and it's something that we have gotten better than many of other things, and we should continue to do so. So thank you, Doug, for your contributions.
Okay, thank you, Stephanie. I'm going to go out on a limb here and guess that when Doug started his career as a legal academic, he never thought he'd be on TV as a dog. So that's great. I'm thinking, unless Mark tells us that he's on the verge of a total power outage, maybe we'll have Larry go next, and then Mark, you could bring us home. Does that work, Mark, from your perspective? Okay, great. So Larry, we'll turn it over to you.
Although if there's any time issue, I think we should go with Mark and be sure we have him.
He seems happy to let you go, so go ahead, Larry.
Okay. Well, thanks to all of you for setting this up. I'm extraordinarily happy to be here and to help celebrate the extraordinary career of Doug. I'm sorry I'm not there in Austin with all of you to enjoy it. I'm going to talk today about a paper that I've written jointly with Mark Greenberg of UCLA. And it's a paper which may run parallel to some of Doug's remarkable thinking and arguments, but which may also run contrary to some of them. It will be a little hard to sort that out because I'm not going to talk about constitutional law, but talk about the morality of exemptions for religion that has obvious legal implications given the moral content of the free exercise and establishment clauses, but its exact implications are complicated, and I'm not going to try to address them. I'm going to talk about the moral underpinnings. Marx in my paper begins with a proposition that some of you there have spent a lot of time working against. Chris Lund, marvelously so. And that is that there is no moral justification for treating religious commitments, projects, or beliefs differently than the other important projects, commitments, and beliefs that human beings have. And that there's no moral claim for treating religion specially. And indeed, that produces the opposite view, that to the view that was rejected so long ago by some courts, apparently, as we just learned from Stephanie, which is that preferring religious beliefs over other beliefs is itself morally inappropriate. In this paper, we sort of double down on that argument in the following way. We try to make clear that it's not that there are that there will often be important state reasons for overruling religious beliefs. It is that religious beliefs per se do not have a special claim on liberty interests. And we talk about that in various ways. We give the examples that are familiar, that on any view of what religion means, even if we build into religion sort of reasons for preferring it. We say religion is substantively about what makes life worth living, or we say that religion is that which around which people base their lives. That it's easy to give examples where we're not drawn at all to beliefs that they have the wrong content. So the obvious example in many instances is deeply racist beliefs, which could, in some persons' theological orientation, be the important meaning of life could be the purism of a given race. The thing around which people organize their lives could be the purism of a race. Now, that's often responded to by saying, well, that just means that there are reasons for overriding religious beliefs, that religious beliefs have a pro tanto claim on liberty interests, and they can be overridden by social interests. We offer two reasons to think that our objection to the preferred treatment of religion is deeper than that. One is to suggest when we turn our back on a racist religion, we don't have moral regret. We don't say it's a real shame that we can't accommodate this religious belief because it runs into other important concerns. We think it should be discarded and ignored by the community. The other argument we give is we could define religions that aren't harmful, but are nevertheless not appealing. So people for whom the most important thing in life was visiting every new wonderful restaurant here in New York City, where I'm speaking to you from, and revisiting excellent food, we can imagine someone who has built their life around New York restaurants. We can imagine someone for whom eating superb food is transcendental. This is, Babette's feast, and not think that there is any claim on a special liberty interest, even though there's no pro tanto balance. So the first proposition in this paper, and I'm obviously skimming the treetops, is that there is no reason for treating religion in a preferred status when thinking about liberty interests and exemptions. The second proposition in this paper, which again won't be unfamiliar to many of you, is that the way to understand religious liberty and our intuitive draw to it and our ongoing commitment to it in this legal system and others is as an equality principle. And the paper tries to make out in detail an equality principle which both fully or reasonably explains our intuitions and is morally defensible. And the equality principle we put forward is equal regard. And equal regard for us has two prongs. Equal regard is violated whenever a decision goes against a group and an exemption, for example, is refused that might be granted to other groups. And the reason that it is refused is that pervasive in the community are devaluative attitudes towards that individual or groups. And a devaluative attitude is something we could talk about if people are interested in pursuing. It is basically the idea that that individual's or group is in some way deeply disrespected, and their interests and concerns are not valued as highly as others. So when there are pervasive devaluative attitudes, or they exist at all, and when that's the basis of a group losing out in the allocation of a vital resource like an exemption, that's a failure of equal regard. The other prong of the failure of equal regard is if, in the context of this decision, the social message communicated by the decision is one of disrespect or devaluation. When either of those two things are true, and only when those two things are true, do we think there has been a failure of equal regard, and do we think in the context of decisions made across religious fault lines, we think a liberty interest should be recognized. Now, there are a couple of things to say about this view without getting into it in greater detail. One is, it is not an argument for equal treatment. It's an argument for equal regard. And that means that two things are true. First, there will be cases of uniform treatment that nevertheless indicate devaluative attitudes and support a view of that. A common example given by people who object to simple equality tests is, suppose abolition had taken place and no accommodation, even reasonable, simple accommodation, had been made for the religious use of alcohol in ceremonial circumstances. And our view is, under such a circumstance, concluding that the interests of religious groups had been devalued is perfectly appropriate. Same treatment when there is a group with special needs that can be easily met can easily support a conclusion that devaluative attitudes have taken place. So Stephanie's notion that what we need is a test of sort of people don't suffer inappropriate hardships, we think that's built into equal regard at an appropriate degree of strength. The second thing to say is there can be unequal treatment that doesn't flunk equal regard. Most legislation is that way, even some terrible frivolous legislation. If, we prefer corn over wheat or soybeans, we do so for corrupt reasons, that's not a failure of equal regard because devaluative attitudes are not at stake. So that's one interesting feature of equal regard. It is keyed not to equal treatment, but to equal regard. The second one is, it is clearly important that in a community committed to equal regard, that we scrutinize with some care decisions made across religious fault lines. So decisions which favor one religion over another religion, favor non-religion over religion, or religion over non-religion, all those decisions are candidates for worry about failures of equal regard. But there's this very critical element. That is to say, the problems of equal regard are symmetrical. So on this account, secular interests treated worse than religious interests under circumstances where it is reasonable to conclude that there is a failure of equal regard are every bit as much of a constitutional or moral concern as are ones that disfavor religion. Religious fault lines are the site of worry, but the worry is symmetrical. The classic example in the United States, of course, are the selective service cases, Welsh and Seeger. So that's the second proposition, that an equality test can do the work and do the work well that we are inclined to attribute to a distinct religious freestanding interest. The third thing the paper does, and I'm sensitive to time, so I will go quickly here. The paper applies this viewpoint to the situation of mandatory or semi-mandatory vaccinations. I think we stopped talking about COVID vaccinations at some point when it became so hot a topic. So it's probably easier to talk about mandatory measles, mumps, and rubella vaccinations, which, as prior to COVID, had already come under great fire in California. And the obvious notion is that you need to vaccinate most of the people to get herd immunity. And so exemptions from vaccination requirements are a scarce commodity. We're not taking a position for or against mandatory vaccines. We're assuming that the community has made a sensible judgment to impose vaccines in some context, such as you can't come to public school if you're not vaccinated against measles. Measles being highly contagious and very dangerous, and having been put to rest as an illness and now resurging in California and places. And here I'll be very summary. Since equal regard turns on the facts of the matter, namely whether devaluative attitudes cause an outcome, or whether the decision will be perceived as resting on judgments of disrespect and devaluation. You can't look at the vaccination situation without knowing the underlying facts and be sure. So what I'm saying is it is very plausible that the following outcomes would be true in a vaccination regime. The first is, in the vaccination regime, we talk about three contending groups for exemptions. The medically vulnerable, as many of you know, are deeply vulnerable. Their lives can be at stake. Religious objectors to vaccinations, and secular objectors to vaccinations. And the secular anti-vaxxers probably fall into people who have a view about the medical consequences of vaccination, like our recent presidential candidate, and people who hold some philosophical Thoreauian notion of one's body going it alone in some passionate way. So it is entirely possible on our account. First, any sensible government would feel absolutely obliged to provide an exemption for the deeply medically vulnerable. Otherwise, a mandatory vaccination is a kind of a death sentence. So that group has a very powerful claim. If it weren't respected, that would almost certainly be a devaluative judgment and a failure of equal regard. But we think the following are true. First, both of which are potentially provocative in this group. First is that we think it is likely to be the case that an exemption could be granted for the medically vulnerable and denied to religious objectors. We think a community could easily come to that decision without there being any devaluative attitudes or a failure of equal regard. The second may be even more provocative. We think that a community which gave vaccination exemptions to both the medically vulnerable and religious objectors might very well be on equal regard terms obliged to give it to anti-vaxxers as well. Since we don't think that religious objectors intrinsically have a different claim than the anti-vaxxers, and that it might very well be a failure of equal regard not to grant the exemption there. So the paper tries to be about as provocative as it can be for many. And I'm sorry I've done it so summarily, but that's the basic picture. And I hope everyone will be relaxed about this, but I'm looking very much forward to your comments. Thanks very much.
Thank you, Larry. Thank you very much for that presentation, Larry. And now, Mark, we will turn it over to you.
Great.
Assuming your house is still standing.
Yeah. Thanks to all of you for having me. Thanks to Chris and Steve and Rick and Sam for inviting me, and Sandra for sort of helping me navigate this with the hurricane ongoing. The forecast was extremely dire here, and I couldn't leave my 3 young kids and my wife to kind of manage this extreme weather event. I think we're mostly through it, although we've got a bunch of down branches in our yard and, sort of water all over the place. So hopefully we'll stick with it for the next few minutes here. So we already heard about Doug's amazing accomplishments in the field of religious liberty on the first panel, both as a kind of theoretician of religious liberty and as an advocate. I want to talk in my remarks for just a few minutes about Doug's contributions to our understanding of founding era history, especially the history of disestablishment. And Doug has been really influential in that area, influenced me in my own work and many other people. And then I also want to talk just a little bit about Doug's use of that history, sort of the way that his mode of constitutional interpretation is really ecumenical and innovative and, in different ways kind of challenging to standard approaches, originalism and various versions of living constitutionalism, something that we touched on at the end of the last panel too. But before I do that, I just wanted to say a little bit about some experiences that I've had with Doug personally, and how much those experiences have meant to me. So I never took a class with Doug, but I was a graduate student in a different department at the University of Virginia when Doug was there teaching at the law school. And I had the really good fortune of meeting Doug after he agreed to trek across the campus to talk to a group of graduate students about litigating Hosanna Tabor. And I distinctly remember this. I'll never forget it. Doug brought this briefcase full of all the briefs that had been filed in the case, this massive kind of color-coded collection of briefs corresponding to, the petitioners and the amici and so forth. And I remember just marveling at Doug's description of the importance of this issue for religious organizations and really being struck by, these arguments that Doug had made and how important they were to me, how, the connections that they had between the work that I was doing as a scholar in another discipline. And I'm sure that Doug does not remember this, but I remember it just walking out of that meeting and thinking really for the first time, like maybe I should be a law. It was a super important moment for me in my career. And it's enough to go across campus, visit with a group of students he didn't know without any benefit to him. And really since then, I've benefited, in so many ways from Doug's generosity. He's taken time over, several years to comment on papers that I had done in draft form, to talk to me about ideas, and just to share kind of some of his insights about brief writing or just academic life generally. None of that stuff did anything to help Doug, but all of it has helped me just an immeasurable amount. And just one, final kind of story here. One thing that sticks out in my mind, I remember one time in which I'd asked Doug to meet with me to talk about a paper that I was writing. So he came across campus again to meet, in a place that was convenient for me. We talked about the paper, and later I learned that our meeting took place during this very truncated period where the Harvard Law Review had asked him to write a case comment on a recently decided case. And, I think that for me, Doug's willingness to come and talk to an aspiring kind of not yet published scholar during a period that for him, was extremely busy, I think it just says, really everything you need to know about him, about his generosity and his modesty and his character. He's done so much for religious liberty publicly, but he's also done so much for, a lot of people individually. And I include myself in that. So thank you, Doug, for everything that you've done publicly and not so publicly. So I want to talk just a little bit about Doug's contributions to helping really a whole generation of lawyers and scholars think about the founding era history surrounding the religion clauses and the Establishment Clause in particular. Doug is a lawyer, not a historian. He'd be the first person to tell you that. But really, Doug, more effectively than almost anyone else, has bridged the gap between historical material and kind of modern legal questions, highlighting relevant evidence and providing kind of new insights for us on how that evidence relates to modern debates in the law. So I want to talk really briefly about some of the main contributions that Doug has made in that area about our thinking about disestablishment. And I want to talk then a little bit about kind of in the substance, not only, but also the method, how Doug's work provides, what I think is a kind of ecumenical paradigm for thinking about these questions and thinking about, what kinds of roles history can play in constitutional interpretation generally. So first on Doug's substantive contributions, to appreciate kind of the breadth of what Doug has done and what he's taught us about the history of disestablishment, it's sort of the main place to start is the way that Doug has shaped the substance of the debate. And let me just mention sort of three really important areas where Doug's work has played a huge role. I mean, I think of these as sort of, monuments, landmarks, kind of part of the furniture for thinking about the history of disestablishment that, pretty much everybody now takes for granted, but that was very much not the case when Doug started writing about them. The first thing that Doug really did was warn us away from some historical dead ends. So really about the time Doug began, just at the very beginning, writing about the religion clauses, a bunch of people were insisting that understood historically, the Establishment Clause didn't prohibit the government actually from directly sponsoring or even directly funding religion qua religion. All it prohibited is that the government not do so favoring any particular religion. That view, known as non-preferentialism, had some really major support at the time. At least one Supreme Court justice had openly endorsed it. Various officials in the Reagan administration, including Ed Meese, had adopted it. A bunch of scholars were getting on the train, thinking this is really the right approach. Doug responded, again, in one of his earliest articles with really what's now, I think, considered a classic piece of scholarship on this issue, basically just demolishing this theory. And in the process, Doug drew some of these connections that, to my knowledge, had never really been fully appreciated before. Doug did this very deep dive in the different drafts that ultimately led to the ratification of the Establishment Clause, and talked in a really systematic way about how those drafts, expressly considered and rejected this non-preferentialist idea. No one had really appreciated that before. And then he went on to connect this insight with a bunch of debates that had happened in the States, basically where versions of this kind of non-preferentialist idea were presented in debates about things like religious taxes and rejected repeatedly. Rarely, I think, almost never, does a single article sort of go so far in effectively ending a debate among legal scholars, especially where these very powerful forces allayed on the other side. But really, the subsequent events demonstrated that's exactly what Doug did here. That article basically laid this whole theory to rest. And no Supreme Court justice has said anything about non-preferentialism basically since the mid-90s. That alone is amazing, that Doug, in a single article early in his career, was able to basically turn the whole ship about kind of historical interpretations of the Establishment Clause. Really briefly, the other two things I wanted to mention, Doug's historical work has really narrowed some ongoing debates, even where the conversation continues. He's written several articles and then a string of Supreme Court briefs, really arguing that the Establishment Clause the prohibitions that the Establishment Clause places on government extend beyond just coercing religious belief and practice, but they really extend to prohibiting the government from engaging in other kinds of non-coercive support or kind of endorsements of religion. And again, a lot of this work was really original when Doug did it, pointing out that as states got rid of these coercive features of their establishments, these non-coercive features remained, and people still objected. They objected to, say, special statutes for the Episcopal Church in Virginia, or they objected to, very kind of non-coercive versions of establishment in South Carolina, basically just saying, the Protestant Christian religion is the official religion of South Carolina. This stuff, again, hadn't been highlighted in this way and sort of brought to bear directly on some of these controversies, but Doug did that. Some people pushed back against some of Doug's work here. So it's not like it's the same, kind of unanimity that non-preferentialism achieved. But here's the thing I think is amazing. Even then, Doug's work basically forced a bunch of other people to kind of rethink and reassess their position, and really narrowed, I think, the range of disagreement here. People acknowledged that coercion had to be interpreted more broadly than they first thought, or maybe there were non-coercive elements of religious establishment. Again, that's all the result of Doug, all stuff we take for granted now, but was not obvious at the time. Let me mention just one other thing about Doug's work, his historical work. It's his humility in dealing with these historical materials. I mean, Doug's work is really the gold standard when it comes to emphasizing what we know and what we don't know, and trying to draw sort of some appropriate inferences without overclaiming. Doug always resisted throughout his whole career the impulse to engage in sort of sloganeering about quotes from Madison or Jefferson. Instead, when it came to stuff like funding, how do we think about funding? He stressed the historical distance between our time and the founders' time. They were dealing with special religious assessments, special funding for churches, qua churches. And those aren't the kinds of debates that we're having now. And it doesn't mean the history isn't relevant, but it does mean that in asking what history can tell us, it needs a lot more circumspection and a lot more nuance. It requires extrapolating from what we know to answer questions that the founding generation just didn't ask. And Doug is really the master of this, just sort of rejecting both kind of totalizing skepticism about history and rejecting kind of overbroad claims that history decides modern questions when it really doesn't. So just very briefly in the time that I have left, I want to talk a little bit, not just about the kind of substantive contributions that Doug made with respect to what we know about history and the Establishment Clause, but also kind of how he modeled thinking about, some ways that we might use history. And this is related to kind of some of the comments that folks made on the last panel. Doug is a methodological pluralist, but I think that pluralism has been a huge benefit. It really has pushed back, at least in my mind, on some versions of both living constitutionalism and originalism, and really challenged both of those with sort of the primacy of the constitutional text. So Doug, here's how Doug talks about constitutional interpretation and what he thinks is about. This is from, circa 1990. I'll just read you the sentence. It says, constitutional interpretation requires the identification of coherent principles in the constitutional text, reasoned elaboration of the implications of those principles, and application of those principles to current conditions. And when you hear kind of coherent principles and current conditions, you might think that, we're in the world of Ronald Dworkin, where we're asking about moral principles that we can sort of, take from the Constitution, but really bring for us to kind of create a better world. I don't think that's really what Doug means in this passage, and his work on the founding era history sort of reflects that. Like, Doug has this idea that it's the constitutional text that's paramount, and what we're looking for is the principles in the text, principles that were agreed on maybe partially at the founding, maybe elaborated on at some future time. And something that he said earlier, principles that we're going to read against kind of the historical controversies that created the Constitution, the abuses that occasioned those protections. Principles matter, including moral principles, but it's not our principles really. It's really the constitutional text that's supreme, not our moral intuitions. And this relates to, I think, another aspect of Doug's kind of interpretive method over time that I think has really challenged originalists. And this is the last point I'll make. in a series of Establishment Clause cases, various justices, kind of more originalist or originalist minded, have said that we should interpret the Establishment Clause according to historical practices and understandings. But when making that claim, some of these justices have sometimes, insisted that basically the mere existence of a longstanding practice necessarily means the practice is and always was constitutional. And probably the most well-known example of this is Justice Scalia and a majority of the court have basically said, we don't need to inquire into the permissibility of legislative prayer because the bare fact that those practices were carried on by the first Congress means that they're permissible. And Doug has called out these arguments repeatedly, and I think very persuasively, as being wrong, and just for a simple reason. These kinds of arguments are not acts of interpretation at all. We're not, these arguments aren't trying to seek out a positive reading of the Constitution in light of contemporary practice. They're basically just saying, I don't need to give an account of what the Constitution means. If the founders did it, it's good enough for me. And I think Doug's kind of pushing back on that argument has been a huge contribution because it just reveals the kind of fundamental problem here. It just inverts our system of written law. And here's just one sentence that Doug wrote. Again, just this one sentence that I think does it. He says this argument that historical practice is permitted just because the framers did it. It lets the behavior of government officials control the meaning of the Constitution when the whole point is for the Constitution to control the behavior of government officials. And I that's just one of those phrases, again, that I just think gets to the heart of the issue. I don't know, Doug knows about more of his methodology than I do, but I guess reading it in light of these historical contributions he's made, one of the things that strikes me is that Doug is really, rallying in favor of the constitutional text as the kind of primary authority over history, over our own moral intuitions, right? Trying to escape the text or sort of arrive at different results through some other authoritative means. I see Doug as just consistently rejecting that. And I think that is an amazing contribution, not just to the substance of disestablishment, but really to our thinking about what it means to interpret the Constitution.
Thank you, Mark. So we only have about 6 minutes left. We don't have a lot of time here, but in this panel. But I'd like to throw something out that I hope will maybe give Doug an opportunity to respond, and then also just get us all thinking. And it relates to some of Larry's comments. If we could bring Larry back up so we can see both Larry and Mark, that would be great. Assuming Larry's still there.
I'm here.
Okay, great. It's not clear to me as I've grappled with both Larry's work and Doug's work over the years that at the end of the day, if you look at the practical implications of how cases and laws would come out, that there would be dramatic differences in outcomes. That's not clear to me. What obviously is different is the two frameworks the two of you would use to get there. Doug seems to be trying to make sense of the text. Larry, you've come up with this very different framework that doesn't try to make sense of the text. And one thing that strikes me as an interesting difference in my view anyway is that, Larry, you seem to have created or recognize a difference between religious beliefs and non-religious beliefs. Whereas Doug, in your framework, it seems to me anyway, you often say that the religion are the answers to religious questions, and that includes the answers of atheists and agnostics. So under that view, everybody has various religious beliefs. The fairness concern maybe isn't as worrisome because at some point or another, we are all going to be protected one way or another, even if we may not be protected in one particular instance. And so it's this right there at the beginning, you've got a different way of just looking at religion as you're trying to solve the difficult question of how do we allow people of very different religious beliefs to thrive alongside one another in the same society. So I guess my question is, really, where does the difference lie between both of your beliefs? And I'd love to hear, either one of you can start, but if we could get a microphone to Doug, I'd like to just see, really what is the difference here. Larry, why don't you go ahead and go while we get a mic to Doug?
Well, I think we should hear from Doug, and I'm looking forward to seeing and hearing from Doug. At this point, Doug and I have in common a commitment to equality of something as a driving force in the context of religious liberty. Some differences would emerge when we talk about ideas like most favored nation, because most favored nation suggests that in any given context, you can describe some individuals as enjoying the privilege of religion and other individuals not. And I don't think you can flatten that fact or the worry of the moral impropriety of that by saying that it's a question of what questions one is asking. That tends to point towards a capacious and somewhat loaded definition of religion. But I don't think that the fairness objection can be overcome. And I think one consequence, which most favored nation is antithetical to, is that the secular belief in any given context contends. And again, we could think of cases like Seeger and Welsh.
Doug?
I think that if Larry were our judiciary, a single judge judiciary with somehow superhuman powers to decide all the cases, the religious liberty cases would mostly come out pretty well. I think his system is far too complicated for any of the real judges that we have. They would never get there. They would never see the analogies that Larry sees. And I think his starting point is fundamentally different from mine. I start with the Constitution. He starts with his understanding of moral philosophy. At the end of the day, we do come out to many of the same places.
I'd be pretty content with Doug as the apex court.
So in our last minute, I'm sorry, audience members, we don't have time for more questions, but I'd love, Mark or Stephanie, do you have anything, closing comments you'd like to make based on what other people have said or even this last little exchange between Larry and Doug?
I have one thought.
Yeah, go ahead. Bring us home, Stephanie.
Larry was talking about ways in which there might be problems giving exemptions in the vaccination context just because some exemptions were provided to someone for medical reasons, but not religious reasons, or he was just at least touching on some of the complications there. And that's something else that Doug has written about. And one of the arguments that Doug has made is that secular exemptions aren't going to mean that there's a problem, a devaluing of religious liberty, or some reason why we ought to necessarily provide an exemption for religious liberty if that secular exemption is justified by a separate compelling government interest. And so there's debate about whether or not that's true with those exemptions in the vaccine context, but I think that's an important contribution Doug has made and a clarification for why not all secular exemptions are going to be equally relevant from an evidentiary basis, and that a lot of that analysis gets fleshed out on the strict scrutiny side of things, not at the triggering event on the front end, which would make any secular exemption to laws fatal. So just wanted to add that to joint issue between that discussion Larry was having that points of Doug has made.
Okay, thank you so much. Can we have a round of applause for our panelists?